The War Powers Resolution is this complicated framework whereby the president can decide to commit military forces in an emergency, but then he has to go back to Congress, et cetera, which has been criticized by many scholars as too complicated and unwieldy. But the basic premise was to reaffirm the constitutional notion, which is written into the Constitution, that the Congress declares war. The president's in commander-in-chief, but the Congress declares war. And this administration, Vice President Cheney and the lawyers who he hires to work for him, have long taken the position that the defense of the nation was a matter to be decided by the president in secret, that it's not a totally new position, because his father, for example, in the case of the first Gulf War, when the Congress did finally vote to authorize the invasion of Kuwait and the repelling of Iraq, told the Congress that should the Congress disapprove that military action, their view was that they had the constitutional power to commit U.S. forces anyway. But this administration has gone much further in trying to institutionalize that view of presidential power, not just in the question of going to war, but in lots of other related questions. And certainly since 9/11, they've taken the position that the United States is in such danger that only the president can decide these issues. And by the way, he is entitled to do so in secret from the Congress and secret from the public.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.